Dear listeners, welcome back to IP Stories. Today's episode is a deep dive into the world of AI, robotics, and intellectual property by the hand of Dr. Luke McDonagh from LSE Law School. Have you ever wondered what happens if a robot invents something? Or how copyright applies to a performance created by artificial intelligence? Well, we are tackling these big questions and many more, so stick around because this is a conversation you don't want to miss.
Hello, this is IP Stories by 4IP Council, a podcast about innovation and intellectual property. Join us and you'll hear about the journeys through invention, creation, and IP understanding of our guests.
I'm Axel.
And I'm Marta, and we have with us today Dr. Luke McDonagh, Associate Professor at LSE Law School. Luke, thank you so much for having this chat with us. To start with your career, we've seen how you have worked on such a broad range of topics within IP, from patents and litigation to copyright, interactive robotics, cultural property, and even the intersection of IP and theatre. What is it about IP law that keeps drawing you in?
It's a great question, and thank you for inviting me onto the podcast to answer it. I think the answer has to be something to do with creativity. So, the way in which we as humans seek to create, to invent, to do new things, and the relationship between creativity, technology, and the law. So, if you look back through the history of the last 300 years, it is very much the history of the Industrial Revolution, of an idea of progress and of creativity with new technologies from the printing press and the steam train to the smartphone and the MP3, the kind of technology that we take for granted perhaps. But when you look back through the history books, you find that there's always been a fascinating relationship between the creators, the technology, the law, and what becomes the market, the place where, in the time of Shakespeare, people went to hear his plays, to watch them. When printing came in, it helped to create a market for the novel alongside rising literacy. So, and then people made claims to own rights over books and plays and music. And so as these things become more valuable, you get people who make property claims over them, and the law has to intervene. So I think of it as a kind of relationship that is changing all the time. And for me, that's quite exciting. So I keep coming back to these questions to do with intellectual property, cultural property, because to me, they are exciting in that way.
I mean, this is great because when we were preparing this podcast, we saw that you have a very broad international perspective. I think that you researched and also taught in Japan, China, and Italy, among other places. But how have those experiences shaped your understanding of IP law? And in particular, where different legal traditions approach things differently?
Yeah, it's also a great question. I've had quite a lot of good fortune in having been invited to give lectures in different parts of the world. For example, I've been a visiting scholar at Waseda University in Tokyo and also at Keio University, and I've given classes at both institutions. Similarly, I've spent a week teaching at Tongji University in Shanghai back in 2019, teaching on their WIPO Masters on Intellectual Property. I was a visitor at Scuola Sant'Anna in Italy in 2017 as part of the Erasmus teaching exchange. That was fascinating. I've also um, presented my work at the National University of Mexico. And at each place that you go, you learn something new about the legal culture in that jurisdiction, about the types of students and academics that are present, And I think that it's a great thing to do if you ever get the opportunity is to go to another jurisdiction that's very different to yours and think about that as a lawyer and as a teacher. The whole way that we teach law in the UK and Ireland, my as a student learning the law for the first time at the University of Galway, it was through the common law tradition that the UK and Ireland share. It's very different in other parts of the world. Even somewhere as close as Italy or as France has a very different legal tradition, much more codified. The role of the judge is quite different. And then when you go to places like Japan and China, thinking about something like the patent system, they've been very influenced by the German patent system. And you get a sense in both places, in both in Japan and in China, that the IP moment has been an important one in the development of both of those countries. Obviously, it happened in Japan earlier. So in the decades after World War II, Japan developed very, very quickly and became an economic power, and now has that status as a large, high income economy. Even if you go back in China 40 years, it was really a developing country in the 1980s. It was very poor in many respects, didn't have much industry. And look at it now, the amount of technology that is there. And China's making more patent applications in some areas of technology than anywhere else. So there's been a relationship with the way those countries have developed that follows a similar pattern to elsewhere. And so getting out of our own heads and our own jurisdictions as Europeans and going around to different parts of the world to see what's happening can be a fascinating way to learn about what's happening there, but also to learn things that you may have forgotten about your own kind of cultural and economic history. Um, and again, it comes back to that key relationship between the creators or the inventors, the technologies at hand, the market, and the law. And in the areas of patent law and trademark law, the offices of registration become very important because they're the gatekeepers of these property rights. So certainly they've shaped my own experiences as a lawyer and as a teacher. You get great questions all over the world when you're doing seminars on IP law in various ways. It's a privilege to be an English speaker because in most places you can go and give a talk in English. Certainly, that's been my experience. Occasionally, translations can be necessary, but in my experience, the classes that I've taught, I've been incredibly impressed at how students have been able to ask questions in English and give a lot to the dialogue that you have as part of that Q&A process.
That's great. Thank you, Luke. And as we are on this special about robotics and IP, I think maybe it would be nice if you could explain to all of us what aspects of robotics can be protected with IP.
Well, the answer to that is almost all aspects of robotics fall within some kind of framework. Doesn't mean everything is protected by intellectual property rights, but a lot can be. Some programmers who are working with software that helps the robots to run may decide to keep the software open source. So they may decide to, rather than take it as a proprietary model for the software, that might be released as an open source project, or they may use somebody else's open source operational software. Obviously, software can be protected through copyright law, and that underpins the open source projects because essentially each author on the chain agrees to transfer the right to make changes to the next person down the chain without requiring the permission. So it's a very permissive system, but IP is there underpinning that. So when you meet people from robotic firms, they will very much say, well, our software and our hardware are different. The software will have some sort of copyright, though we may be using an open source model. When it comes to specific algorithms, if they've developed one themselves, they may be protecting that as a trade secret. So a lot of algorithms, most famous being the Google search algorithm, though algorithms are now so prominent, I think all of your listeners will know what I'm talking about. A lot of these are kept as trade secrets, so they're not public and they're only accessible to people within the company. So understanding that, the hardware becomes another area, and patents kick in a big way there. Because with anything physical, a physical invention like a robotic exoskeleton or something like that, if somebody can dismantle it and figure out how it works, the hardware, then that's reverse engineering. So trying to protect that as a trade secret isn't going to work because anybody who's a specialist in that area can figure out how it works, and therefore they have the knowledge. So the viability of a patent is that you get your 20 years of exclusivity, and if anyone wants to use that particular piece of hardware, they need to come to you. There are occasionally, though it's hard to get, there can be some patents that interlink software and hardware. Technical inventions are permissible, though they're harder to get through the patent examination system. And then, of course, you've got trademarks. So all the robotics companies that I've spoken to over the years have had a logo, they've had a name, so they've registered that so that they have their brand that they can take around. And on top of that, we've also got design law. So I once went to the European Robotics Forum and I met a company that was specializing in educational robots that help children to learn, and particularly helping children who have quite severe autism to learn. And a lot of what they said their added value as a company was that their robots were designed to be friendly looking. They could not be scary because you're dealing with children. You have to make sure that the children can trust this robot. And so they made the robot look quite cartoonish, quite friendly, and they said that they had applied for design rights on aspects of the design of the robot. So we've got copyright, trade secrets, patents, designs, trademarks, everything comes into this. And it also, dealing with the robots is something that I encountered in Scuola Sant'Anna in Pisa. They have a spin out that does robotics. At the National University of Mexico, they're very uh, the quality of their research on robots is very high, but they've actually struggled to create spin outs. And then if you go to Japan, they're extremely good at this. So a lot of the universities have a connection to the private sector. They do a lot on robotics. And so each market has its own set of spin outs that use robotics in this creative way. There's often a link back to university research. And the network that I was involved in before I joined LSE, I was involved in a network called InBots with my colleague Enrico Bonadio, and we were partnering on robotics projects to do with intellectual property. And that's what took us to these different places together to learn about what firms were doing, what university researchers were doing, and to try to unpack all of these different levels of IP that make up what a robotics company would call their IP portfolio. And so it really is a very diverse range, and most companies don't go 100% on all of these different rights. As I say, if they've got a lot invested in their patents, they'll focus on that and maybe use open source software that someone else developed. On the other hand, if they're more thinking about keeping their algorithm private, then that's what they'll do. They'll keep it as a trade secret and maybe use robotic uh, physical robotics inventions that are already out there and in the public domain.
It's amazing because it's like a blend of everything. You know, robotics is improving day after day, and even the last few years, we could see that it was not enough. So we had this additional ingredient that was added to the mix, which is AI. So if we look at AI powered robots becoming more autonomous and capable of complex decision making, what do you see as the biggest legal challenges, for example? Or are we heading towards a major shift in how we define inventorship and authorship?
I think that we are, at least in some senses. I'm sure that some of your listeners will have been aware that there's been a big consultation on AI and IP in the UK over the last few months. Recently, the music industry got together and a silent album was released to protest the use of music by AI companies to train their databases without permission. And so there's a lot going on here that is going to affect creativity in a big way. But it is important to, again, take a historical view here. A few years ago, the German magazine Der Spiegel did a story where they went back to their own archives over a century to find all of the covers of their magazine that said the robots are going to take our jobs. And they found 5 or 6 from different eras. You know, if you go back to any era of automation, there's this fear that automation is going to take our jobs, disrupt our creativity, destroy our skills, and so on. And a big part of that is true. That is what happens in many respects. But it also brings extraordinary opportunities and it changes the nature of work. The use of robots in a number of different industries has made, for example, factories safer. You know, rather than human hands doing certain tasks, robotic hands, you know, if they get broken, it might cost the company a bit of money, but it's not a human being injured. If we think about complex surgeries now being used with robotic arms, you know, that's been the case for a long time. When it comes to robots doing more creative things. You know, 5 or 6 years ago, we had the example of the next Rembrandt, where the project was all about scanning all of the Rijksmuseum's Rembrandts using an algorithmic process. So we had software and hardware interacting. So the algorithm told the robotic hand what to do, and the robotic hand painted a painting in the style of Rembrandt. Now, whether it was a wonderful painting or a really quite poor pastiche of Rembrandt is entirely up to the viewer. But it's an impressive technical achievement. I think we can agree on that. And so that idea that a robot can do something that we would normally consider to be a creative act is becoming more and more obvious. The key thing for this moment seems to be more about the software side than the hardware side. You know, when you meet people in the robotics industry, they have had a lot of useful hardware for a long time, but the kind of generative algorithmic creativity that's happening now takes us leaps beyond what was possible before. So, in terms of redefining inventorship and authorship, one of the questions that we need to ask is whether we want to prioritize the human in these processes, or whether we want to accept that AI influencing our creativity is going to be something that is here to stay and is already being used in Hollywood movies. For example, Adrian Brody's voice was altered in post production to correct his Hungarian accent in the film The Brutalist, and he's just won the Academy Award for that performance. And so it's becoming more and more acceptable to do that sort of thing. For those of us who are listeners of podcasts, we're in the middle of one right now. You can generate an AI podcast now quite easily. And so it's a challenge for all of us for what this means. And it means that at one stage, one part of it means that humans have to do more. We have to actually show beyond the the kind of the basic average creativity that AI can do. We need to try to give some added value beyond that. Otherwise, why listen to this podcast when you can listen to two robots speak to one another?
Yeah, I think that's such an interesting point because there are days that I find that AI and generative AI is something that it's playing on my side, and there are days that it's like, oh my god, I do understand as well that that panic that you were talking about before, and it's interesting how it has happened throughout history so many times, and of course it's going to create so many other opportunities and so many other different jobs, but I understand that change is not easy, and I think we all need to find out, as you were saying, like how are we going to continue contributing with value, and yeah, I think it almost goes more like into philosophy than anything else. Um, I would like to take what you were mentioning about AI robots, and I don't know, like maybe this is a question that for lawyers seems very obvious, but something that I was wondering is what happens if a robot invents something on its own without direct human input? So that in that case, who would own the rights? Would this be the software developer of the AI within the robot? The robot might be the owner or maybe the user, or like, do we need to rethink IP entirely for cases like this?
It's an open question, and it will be resolved in the next 4 or 5 years probably, because the pressures to resolve this question are really coming to bear in the litigation and in other respects. Right now, the way that most jurisdictions have dealt with this with regard to patents and artificial intelligence is that patent law requires a human inventor. That's what the UK Supreme Court has said. That seems to be the case in most jurisdictions. There are a couple that haven't agreed with that. Um, but in a way, it's a kind of noble lie, and it may not be sustainable. And here's the reason. We know for a fact that a lot of drug discovery, for example, and a lot of patents coming out of that are being are coming out of a process in which the humans in the lab are using algorithmic processes, they're using algorithmic creativity, they're able to do things much faster using AI. And undoubtedly, some of the inventions coming out of these labs would not have been created but for the use of the AI tools to get the humans there, at least to get them there so quickly. And some of these inventions may not have ever come up without the use of those tools that allow you to get from A to Z so quickly. So we know that that's happening. Google DeepMind won the Nobel Prize last year for its use of algorithmic creativity, data mining, invention in processes of chemistry and drug discovery. So we know it's happening. What the patent system has said in the UK and in other places, for the most part, is that you cannot put the AI program on the patent application as an inventor because only humans can be named as an inventor. But you can use it to create the invention and then not disclose that you've used it. And so in my work with Enrico Bonadio on this question, that's one of the issues that we highlight, that the law here seems to be facilitating inventors to not tell the truth about the way that this has been done. And when it comes to questions like inventive step, one of the criteria for getting a patent, if it's the case that the machine is doing most of the actual inventing and the human's job is just to recognize when it works or when they found the right compound, then it's a very different type of invention than we have usually envisaged. But at the moment, the patent system seems to be going along with this noble lie that the human is still the center of the process. We're definitely not at the stage yet when the robot or the AI is doing it entirely by itself. We don't have that artificial general intelligence yet in which a robot could make its own choices about what to do. So right now, this is still being directed by a human. It's telling the AI to do something. The AI is often doing this um, much quicker than any human could, and in some respects could be making choices in its own algorithmic way. So these are not choices that come out of a personality, these are choices that come out of essentially trillions of data points being crunched together. And so if we think of that as a creative process, as an inventive process, if that produces something patentable, if that produces a song that everybody likes, then we are getting to a position where we have to make a decision about things like authorship, ownership, inventorship. And we are edging towards that place, but we're not quite there yet. At the moment, our current systems are able to keep going. Um, and that the main issue has become in the last couple of years less about what the AI is able to claim as authorship and more about whether human authors will get paid for the use of their works in the training data. That has become much more significant in the public eye. And that's the issue that will be resolved in some way or form within the next couple of years because it has to be. There will either be some sort of licensing solution or there will be some sort of exception within the law that's recognized that allows that to take place. But we have to find a solution to that because that's the pressing problem that the music industry, the film industry, authors, and the AI industry are thrashing out in the courts right now.
Yeah, that's happening a lot. Hmm.
That's fascinating because so, I like this direction where we are going. Robotics and creativity. Um, it gives me many ideas. But in your book, Performing Copyright, you dive into how law, theater, and authorship intersect, like where ownership and originality blur. But in some way, copyright laws are too rigid for today's world. Do you think they really protect live performances or miss the mark with newer art forms like robotic performances, which is something new? No, robotic art. How should we rethink copyright for the digital age?
Well, one of the interesting things here, now that we've come back to theatre, which is the subject of my book, is that the term robot comes from a play called RUR by the Czech writer Karel Čapek in 1920. So this comes out of a theatrical idiom, this whole idea of a robot. And even though in that play, the robot, the play's the RUR stands for Rossum's Universal Robots. That's the English translation of the play. The robot is a biological, artificial person rather than a fully mechanized person. It's an idea that was born out of a theatrical experience. This idea that we have almost a mirror image in technology that we can create as humans that makes us rethink our own humanity, our relationship to God or the gods, depending on what you believe. And so bringing it to that question of theater, I think, is very appropriate in the context of robotics. There are elements of technology that have always been part of theater productions. If you go back to the Victorian era, there were new mechanisms like trapdoors and smoke spectacles and that sort of thing to enhance the theatrical experience. And you now have more use of technology on stage, sometimes even robots used on stage. There have been questions litigated in different jurisdictions around the world. In Australia, a few years ago, there was a fascinating case about whether a firework display could be a copyright work. And so when we think about these, because it's an arrangement that a human has gone to quite a lot of trouble to put into place, and so these kinds of questions will continue to come up, no doubt about it. The question of whether copyright is too rigid for the technologies of today's world is the eternal question that we've been dealing with since the Industrial Revolution and even before. When the printing press came along, it fundamentally changed the nature of technology and the law and readership. It created a market that paved the way for rising literacy, rising art forms like the novel, which comes out of that era. In the field of theatre, you didn't have the right to protect the performance of your work until the mid 19th century in Britain. And because you had the right to protect your work in print under the Statute of Anne, but you didn't have the right to prevent someone from going on stage and doing an adaptation or a theatre version of your novel. And so the law has evolved as technologies have changed, and it always has done, always will do. When we look at theatre, it was the primary form of art until film and TV came along and disrupted it. And people moved to those areas. Obviously, we still have a thriving theatre scene, but it doesn't get the audiences that a big blockbuster movie or TV show will. That was a technological disruption that affected the industry. So, thinking about this as a common law copyright lawyer, the law can evolve. Concepts like the copyright work can evolve. Concepts like authorship can evolve within a certain kind of trajectory, let's say. And we haven't yet had the case in the UK, which we're all waiting for, which is the Getty Images case. This will be one of the big cases globally, and certainly for the UK jurisdiction. It is likely to be the big ruling which decides, is it an infringing use to train AI using someone else's photographs, someone else's music, someone else's literature? We haven't got that ruling yet. And that ruling will either show that the law as it stands now can evolve to meet this moment, or it could show that we need new legislation and a new approach. There have always been these moments. 1710 is the first copyright statute. There's more legislation in the 19th century. The 1911 Copyright Act is the first time in the UK that copyright becomes a bundle of rights after the Berne Convention. Then we've got, the law we have now from 1988. It may be time to think again if things do change profoundly, or the law might be able to evolve and use the concepts that we have, but in this new form.
And if you had to choose areas where you think mm, we are facing the biggest challenge regarding IP law, and probably they will eventually need a reform, what specific areas do you think those would be?
Well, certainly the area of trade secrets and IP law needs more attention. We have often neglected it because there's so much to study in IP law. many people go into copyright law, trademark law, patent law. There's many PhDs every year that people are writing on this. It's relatively rare for somebody to do design law as a PhD, and it's relatively rare to do trade secrets, though it's getting more popular. It's certainly becoming more important with things like algorithms where some companies are choosing not to even attempt to get a patent, but just to keep it as a trade secret. In a way, the technology it lends itself to that, as Google has shown with its own algorithm um, for search. And so that brings challenges for IP, if because we're seeing, for example, in the pharmaceutical field, more and more being protected through trade secrets, processes, know-how, and so on, how to make something. And with complex biologics, large molecule drugs, it might be difficult to make that drug, even if you're an experienced generic producer, simply by going to the patents, looking at what's there. Because there's so many patents now being granted on even a single drug, because the drugs are getting more complicated. And then it may be difficult to figure out the process of manufacture, of stitching all together the various patented bits of technology into a working vaccine or a working large molecule drug. And so the trade secrets that are being kept behind closed doors or digital walls, so to speak, are becoming more and more important, more and more valuable, but they're posing a challenge to us because our IP laws were not developed to allow easy access to trade secrets. And so one of the papers I've been working on recently with one of my colleagues, Dr. Olga Gergula Brunel, is about whether we can have a system in the UK of compulsory licensing of trade secrets alongside compulsory licensing of patents. So trade secrets are certainly something that are going to grow in importance. We see this also in the AI field because a lot of times when AI companies are developing data sets alongside their algorithm and they're training their AI programs using these huge data sets, some of which have not been paid for, some of which may have even come from pirated music sites and so on. When they're doing that, and then, a musician like Ed Sheeran or Kate Bush or Damon Albarn, all the musicians who were involved in the recent protest, when they come and say, well, are you using our music without permission? Or the authors say, are you using our books without permission? The companies are often saying, our database is our trade secret and you can't look at it. And so there's this interesting battle within IP where um, trade secrets are being used almost as a way to block these searches for evidence of an infringement of a different form of IP in copyright law. And with trade secrets, we also have the issue that it's not fully accepted in all jurisdictions as a form of IP. It's not fully codified as such in many statutes. It's developed in the UK as breach of confidence, which is a common law doctrine. In some jurisdictions like the US, it is seen as intellectual property, but that's not universally the case. And so it has this ambiguous status that will need to be explored more and more in the years to come. So whether it be in healthcare, whether it be in robotics and AI, I think that as a subject, trade secrets is the area we need to get to grips with more than any other at the moment and probably for the next few years.
You just raised so many topics. I'm confident that many of our listeners will get inspired. We have a lot of young professionals and students listening to this podcast. And then my final question for you would be for the young professionals and master students, PhD students listening to this podcast and interested in IP law, what's what is one piece of advice you will give them as they navigate this ever evolving field?
It's a great question, and I try to give this advice to my own students, which is if you're interested in intellectual property, most people will have an inkling of which part of it they like the most, that they're passionate about. It's very, very rare. I don't think I've ever met anybody who is equally as interested in all the different aspects of IP. And we've mentioned those 5 aspects today: copyright, patents, trademarks, trade secrets, designs. So if you think about all of that, it's so diverse and so technical. Nobody could be the perfect expert in all of those areas. So you do have to make choices, I think, in terms of your interests and what you're most passionate about. But once you've done that, whether it be, let's say, trademarks and fashion, it might be copyright and the music industry, it might be patents and the engineering sector, or patents in the pharmaceutical sector, it might be designs and new robotic kind of innovations, or something to do with trade secrets, as we've just mentioned. I think follow it with passion and be prepared to work very hard, because this is an exciting area of law. That's why people get interested in it and why they tend to stick with it. It is within the broader area of commercial law, so there's a lot of opportunities. There's a lot of people that I know who have started out maybe on an academic track and then have gone to work as a consultant or have started their own podcast. And there's others that I know who have gone into the corporate law side, but to work in the IP section of a big firm. There's others who have worked maybe in the art law or cultural property side, which is its own specialist area. Others working at the bar or in advocacy, people who work in the NGO sector. There's a lot going on in this area of law, and so it is important that you do those 2 things: follow your passion and work hard. And there will be opportunities, because this simply is an area where those opportunities um, are numerous and ever changing. And we all of us working in this area, whether you're in the kind of professional private sector, whether you're in academia, wherever you are, you need to keep up to date. This is not, the history of this subject is very important. It's important to me, but the subject itself changes all the time, and you need to be keeping up with the latest cases that are coming out, the latest concepts. So follow your passion, work hard, and I think that it can be very rewarding to look at intellectual property, whether or not you're fully on board with it. You can be a very effective critic of IP. That's needed too, to help balance the system. There's a lot that you can do with this field, and so I would just encourage anyone that if they're interested at all, make a decision about what side of it you really want to go for, and do that as well as you can.
I think that was great advice. Thank you so much, Luke, for spending this time with us. It was such a pleasure to have you.
Thank you very much, Luke.
Thank you.
Okay, well, have a lovely day, you too, and bye bye.
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 Thank you for listening to IP Stories by 4IP Council. Visit our website on 4ipcouncil.eu to find out more and check out the links mentioned during this episode. If you liked it, remember to share and subscribe.